Welcome everyone to the second day of our week-long SIEPR Economic Summit. I'm Mark Duggan, the Trione Director of the Stanford Institute for Economic Policy Research, and I'm delighted that you're tuning in for today's session on probing the limits of antitrust policy in the era of big tech. I hope that you were able to join us yesterday when I had what I think was a great conversation with Melody Hobson from Ariel Investments. And if you missed that, or if you have to miss any of our other main sessions, we'll have recordings for you to watch later posted on our website. So please check out siepr.stanford.edu next week, and you'll be able to find anything you missed this week or be able to share links to anything that you found particularly interesting. We're kicking things off today with a topic that I know is top of mind for a lot of us here in Silicon Valley and elsewhere who are simply interested in technology. And that topic is competition and regulation in the era of big tech. We have an outstanding lineup of panelists who you'll be meeting in just a minute, but let me first introduce our moderator for the session, Jean Sykes. Jean is a good friend of ours at SIEPR, who was actually with us 3 years ago at the 2018 summit, moderating a session on the economics of the Olympics and Paralympic Games. He's a member of Stanford's Board of Trustees and also sits on the Advisory Council for the Stanford Graduate School of Business. Jean is a senior partner of Goldman Sachs, and he's also chairman for the Alliance for Southern California Innovation and serves on the boards of the Pacific Council on International Policy and Common Sense Media. I could go on and on talking about Jean and his many accomplishments and his Stanford connections, but I'll just stop myself here and turn things over to him so he can get the conversation started with our panelists here to talk about the limits of antitrust policy in the era of big tech. Welcome, Jean.
Thanks, Mark. It's a pleasure to be with you, and I think this will be a very interesting discussion. So the question before us is big tech and the fact of big technology influencing the lives of everybody in the country and everybody in the world is a phenomenon that's a new phenomenon. Antitrust policy has been developed over 100 years. But antitrust policy is the mechanism by which a lot of regulation and oversight and policy objectives are determined when it comes to engaging with businesses, especially as they buy or sell or merge or do big strategic things. That's the practice that I've been engaged in myself for 40 years at Goldman Sachs, so I'm very familiar with it. And so the question really is, does antitrust policy do the trick, or should we be doing something different than conventional antitrust policy? So to explore that question, we have three very, very prominent and experienced people, two economists and a lawyer, all of whom have been deeply engaged in antitrust and its application for some time. So let me introduce the three of them, then we'll open up the discussion. First is Nancy Rose. She is the Charles P. Kindleberger Professor of Applied Economics and the former department head of the MIT Economics Department. Her current research on the economic and legal foundations for more effective antitrust enforcement builds on her experience as Deputy Assistant Attorney General for Economic Analysis in the DOJ Antitrust Division. Next, we have Tim Bresnahan. Tim is a SIEPR Senior Fellow Emeritus and Professor of Economics at Stanford. He's also, by courtesy of the Stanford Business School. He serves as co-director of the Stanford Computer Industry Project and co-director of the Technology and Economic Growth Program in SIEPR. A 1975 graduate of Haverford College, he received a PhD in economics from Princeton. His research interests lie in the industrial organization area. He's been concerned with econometric measurement of market power and testing of models in imperfect competition. He served as chief economist of the Antitrust Division of the US Department of Justice. Next, we have Doug Melamed. He is professor of the practice of law at Stanford Law School. He joined the Stanford faculty in 2014, and in the fall of 2017, he was the Florence Rogatz visiting professor in the practice of law at Yale Law School. From 2009 until 2014, Doug was the senior vice president and general counsel of Intel. And prior to joining Intel in 2009, he was chair of the Antitrust and Competition Practice Group of WilmerHale. He joined WilmerHale's predecessor in 1971, and from 1996 to 2001, he served in the US Department of Justice as acting assistant attorney general in charge of the Antitrust Division. And before that, as principal deputy assistant attorney general. So you can see between the three of them, we have people with a tremendous amount of expertise and the ability to give us some insight into this big question. So maybe I'll open up the question first, and I want to make sure I tell all the people who are viewing this to use the chat screen to send questions. The questions will come to me, and I'll be able to direct your questions. Those questions can come anytime you want. We're going to open it up for live questions after we have 45 minutes or so of discussion between us. So let me start with the question. What problems does big tech pose? And are these competition problems the way that antitrust addresses competition problems, or are they something else? So I'm going to open that up, and I can't remember where we said we'd start, perhaps with Doug, since that was the first question.
Thank you. I think you remembered that correctly, at least the same way I remembered it. I think there's a notion in the political community and perhaps in the public at large that when we have big business enterprises, the solution must lie in antitrust. That somehow antitrust is a tool we use to address and tackle problems posed by big businesses. In fact, as I'll make clear, I'm sure the panel will make clear if we go on, antitrust is much different from and much narrower than that. If you look at the problems that are thought to be posed by the big tech companies, most of the ones that I think have animated the discussion and the hostility really have very little to do with competition, at least directly, or really even economics. And those are concerns about privacy, concerns about the kind of disruption to the political process of the dissemination of misinformation or the censorship of information, depending on what side of the political spectrum you're in, and what might be called the social disintermediation problem of people spending their time in remote chat rooms rather than in their local communities with other kinds of associations and affiliations. Now, to some extent, these problems are related certainly to the size and power of these organizations, and that has an economic dimension. One could look at the power of a company to take actions contrary to the interests of its trading partners, raising price or whatever. You could look at that as an economic problem, or you could look at that, I suppose, as an appropriate and desirable reward to an incentive for the kinds of innovative and entrepreneurial conduct that enabled the companies to gain that sort of dominance. The one area of concern about the tech platforms that is unambiguously a competition problem in the sense at least contemplated by the antitrust laws are the allegations of anti-competitive conduct by the platforms. And that means conduct that tends to diminish competition and doesn't have any benefit to welfare, such as improving product quality or reducing cost or above cost prices. And we are, I think, all familiar with the kinds of allegations: predatory pricing, self-preferencing on the platforms, restrictions on access to distribution by smaller competitors, acquisitions of nascent or potential competitors and the like. These are clearly raised competition issues. And we'll talk about them later, but I think the important point for maybe the beginning purposes is this. Even if all of these allegations that have been taken seriously, at least in the antitrust community, were proven to be well-founded, the remedies that one would obtain, at least under existing antitrust law, would not directly address or change the size or power of the platforms or their business models. Antitrust is much more narrowly focused on specific episodes of anti-competitive conduct.
Let me say that, this is Tim, let me say that I broadly agree with Doug, and to some degrees I would go a little farther. The areas he called non-economic are not areas I would see as likely to be improved by an increase in competition among the big tech firms. You know, the worst is the tendency of everybody to be looking into a screen and not going outside and playing with their kids. That, you know, if you wanted the big tech firms to compete harder, how do they do that? They pull more people to their screens. You know, so competition and the problem, you know, it's just sort of in opposition to a solution to that problem. I'd say that privacy is more of an economic problem, but that regulation on privacy, which we've recently seen from California and before that the European Union, it has been ineffective so far. And again, it's in opposition to competition. We'd like the firms that sell targeted ads, you know, if they were competing more, they'd target them better and they'd sell more of them for cheaper, which of course makes the privacy problem work. So that's a regulation problem, not a competition problem. And then the other one, the other area where I think I would slightly disagree is that there's not just questions of conduct here, but there's also changes in market structure that follow with mergers. So I think I agree completely with Doug's list, but the other area that seems to fall in our turf is where the series of mergers that we've seen in the past, for example, Facebook buying Instagram, might have been subject to more careful antitrust scrutiny, and whether other mergers in the future might as well.
I think I'd expand upon that, Tim. I don't think it's just the mergers. I think I think there should be acknowledgement that many of the problems that people have with tech or that have been raised with respect to tech are not directly competition problems or amenable probably to solutions through antitrust. But I do think that we've had now really decades of under-enforcement of against anti-competitive conduct outside of the merger realm. I think the merger realm is also problematic, but I think we have just really decades at this point of court decisions that are quite hostile to plaintiffs, to the government, or even private plaintiffs, trying to enforce against anti-competitive conduct, exclusionary behavior, companies sort of digging moats around their activity. Doug mentioned self-preferencing, market extensions, and the antitrust system is fundamentally a deterrent system. So if the companies expect that there will not be effective enforcement against that behavior, I think it leads to conduct that is worse than what we would have seen had we been able to sort of nip it in the bud. So I don't think we need to just look at merger and acquisitions as a problem area, but also ask, is there more that we could do on the conduct side?
Well, I'd observed several of these big technology platforms, the trillionaires, as I call them, have not been companies that have expanded by doing a lot of mergers. Amazon's made a few acquisitions. I'm not sure anybody would object to their acquisition of Whole Foods. Maybe that's the biggest thing they've ever done. But they developed the Amazon Web Services business, which is an absolute Goliath, completely on their own. So I'm intrigued because I think Tim was suggesting we have a market structure problem, and the market structure problem may cause consumer harm if antitrust was designed to affect the government's role in protecting consumers through an antitrust enforcement, a deterrent enforcement, as Nancy suggests. What does it mean about the ability for classical definitions of competition and antitrust regulation of competition relative to all of the issues that I think Doug first identified as issues that are thought of as big problems or challenges with the presence of the tech platforms in their very broad reach?
Well, I think you can hear Nancy and me differing more in what we think is feasible than in what we think is desirable. I agree with her absolutely that there's a lot of value in deterring anti-competitive conduct that extends market power, blocks future entrants, and has other bad consequences. Indeed, Doug and I sitting together in the antitrust division were there for the last case, Microsoft, that contributed anything to that deterrence. But with the way the courts are now. The other two branches of government have limited room to maneuver to expand enforcement. We haven't had another big monopolization case in the intervening 2 decades. We haven't had, now merger enforcement, I didn't say only merger enforcement, I said also merger enforcement, because it's the area where there's, where the courts aren't going to automatically say no. I agree absolutely with Nancy that there's been this enormous drift away from thinking monopolization or monopoly power can be a real problem in the court system. I treat it more like a constraint.
Well, let me comment on a couple of things. First, I completely agree that the courts have been very conservative over the past 40 years, and it was an appropriate correction in the first maybe 20 of those, but I think it's gone too far. I disagree perhaps a little bit with Tim, because I think the courts have been very conservative with respect to mergers as well. And if the agencies can't win their merger cases in court, their ability to get even settlements in merger cases is at least to some extent diminished. So the courts matter there. Now, that raises the question of whether, if we want to tinker with the antitrust laws, we can rely on the common law evolution that has been the principal source of change in the antitrust laws for the past 100 years, or whether we need new legislation. But before we get to that, I want to respond to 2 things that Gene said that I think they're important, as I understood it. One was, well, what's the point of encouraging competition if that's really not going to solve these bigger problems we're worried about? If Tim is right that it might exacerbate the privacy problem, and it doesn't do much, and maybe the so-called social disintermediation problem. I think on political speech, it's not quite so clear, because if the platforms had a smaller share of the attention online, then no one of them would have the capacity to impact politics by either censorship or disinformation that they presently have. But beyond that, I think there is an intrinsic value in laws that effectively prohibit anti-competitive conduct, because that's bad conduct. That has economic harm, even if it doesn't address the big problem of political polarization or whatever. And included among the bad conduct, I didn't mean to exclude this, are acquisitions. So that takes me to the second thing I want to briefly comment. And Gene kind of said, well, these companies haven't grown by acquisitions. Even if that were correct, and you can quibble a little bit here and there, the competitive concern is not so much, in fact, it's just the opposite of, did Facebook grow because it was able to combine itself with Instagram and create synergies and create a better products or whatever? Rather, the question is whether some of these acquisitions, vertical or horizontal as the case may be, prevented the emergence of competition that would have eroded the market power of the platforms, or in adjacent markets prevented the platforms from extending their market power into adjacent markets. And that's a very difficult question, because when you're talking about these so-called nascent competitors, where you're asked at the outset of a company's growth to predict whether, if it weren't acquired by the tech platform, it would grow into or become a complement to the kind of real competitive threat that could change things. And that's an area where clearly existing antitrust doctrine, I think, has to be revised one way or another if the laws are going to be able effectively to deal with the competitive threat problems posed by those kinds of acquisitions.
I want to pick up on that just because there was one question from the audience that touched on this point. The question was expressed by saying there are bright economic minds who believe that the damage to the economy from the size and practices of big tech are in the realm of productivity. That is, that acquisitions have stifled the growth of new ideas and productivity growth. Is that something that can be approached by antitrust? Or does that require a new competitive approach? It sort of gets to the comment that you were making.
I think in principle, it's certainly something that antitrust can tackle. Antitrust isn't concerned only with, as some assert, price effects, though that often is the focus at times in certain cases, and courts maybe overstate their focus on price or output effects, but impeding productivity, impeding innovation, even were it possible to present a case and prove it up that certain behavior or certain acquisitions impact privacy adversely. I think that's all something that, as Doug mentioned, antitrust is concerned about how you affect the competitive process and how that may enable you to extract value from your trading partners. But I want to put a sort of finer point on, the kind of distinction between possibility and reality here. And, as both Tim and Doug have mentioned, what we can do in the current environment is limited by what courts are willing to, what arguments courts are willing to entertain and find compelling. And I think one of the problems, if we think about these acquisitions, to just take to pick that up for a moment, the courts have a tremendous difficulty in envisioning or being willing to accept kind of qualitative evidence with respect to potential or nascent competition. And I think what's so problematic about the tech space is that many of these markets seem to be dominated by network effects or economies of scale. That mean that an existing dominant firm may have very little current competition, and that the competitive pressure on it to deliver value to consumers and to society is going to come from the threat that firm is replaced. That's kind of what Doug was mentioning when he was talking about these acquisitions of nascent competitors that prevent the emergence of a rival. And so if courts make it difficult for the government to bring cases that involve that kind of nascent competition, and therefore the antitrust enforcement agencies don't bring those forward, then we're really stuck, because what that does is to say, you can buy up firms before they get to be an obvious competitive threat. Of course, the incumbents have much better information and much better insight about where those threats might emerge than the government enforcers do. They know their industry much better than the folks sitting in Washington, even as talented as the career staff are in both DOJ and the FTC. So I think that, again, hampers the ability under current case law to enforce against this kind of, walling yourself off, preventing others from coming in and threatening your incumbent advantage.
So within the past couple of weeks, we've had new legislation introduced in both the Senate and the House to attempt to add to or reform or make more enforceable a broader definition of antitrust policy. How do you all think about this? And are we going to see something which uses antitrust policy but defines antitrust differently? Or are an entirely new set of regulations really needed to deal with the consequences that we've been talking about?
Well, I guess it sounds like a legal question, so maybe I'll start. There's a big underlying conversation here. The antitrust laws for at least 40 years or so have been exclusively focused on economic welfare. That's the mislabeled consumer welfare standard. The Klobuchar bill is an effort within that framework to calibrate to change some of the legal doctrine in an effort, according to its proponents, to better achieve that economic welfare objective. I think it has some pluses and some minuses. It's a difficult kind of technocratic conversation. The populist critics of antitrust law, who I think were expressed, I think the House reports expressed their views, are not really, or even partially, in my view, focused on economic welfare. They are focused on inequality of power, political power and economic power, and maybe even wealth. So they do want, as you suggested, to change the objectives of antitrust law. That would be a very profound change. At the very, it would on the face of it, it would have very adverse consequences for economic welfare, because those changes would matter only in those cases in which the result is different from the result you would reach if you continued to be exclusively focused on economic welfare. And it would have other problems in terms of making the law incoherent and unpredictable and subject to regulatory capture and so on. So there really are two very different conversations and very different proposals here, but only one of them is really focused on the kinds of economic issues that antitrust has for the last several decades been focused on.
So to pick up on that a bit more, Gene, I think the Klobuchar bill, as Doug mentioned, is kind of squarely within the realm of how antitrust has been interpreted for decades. But recognizing that the ability of the enforcement agencies to enforce that law has been eroded by decisions, I think what it's attempting to do is to say the courts have been too concerned with the cost of over enforcement, and by the way, it's not clear that those costs are significant at all. Certainly in the present environment, or even going back 20 or 30 years, the courts have been far insufficiently concerned with the cost of under enforcement on economic welfare. And I think what the Klobuchar bill is trying to do is to both change some of the burdens and presumptions to restore a kind of balance between that, that the pendulum is tilted so far to the under enforcement direction to try and bring it back. One of the other things that I would mention that isn't in the context of trying to rewrite the standards for enforcement, but I think could have a tremendous impact, is recognition that we have underfunded the enforcement agencies now for decades. When I was at DOJ, we didn't even have time to enforce against all of the anti-competitive mergers that were were obviously problematic, and for which the agencies might be very likely to win challenges in court, because there just weren't the people and there weren't the resources. So one of the things that the Klobuchar bill does is to substantially increase funding for the agencies. And again, given that this is a deterrent system, I think that could have an immediate impact, as we're trying to write the case law as well.
Okay, so on the one hand, we can use antitrust policy as it's established, but reform it, adapt it, maybe modernize it to make it more effective where we see it hasn't been effective. And that includes funding and helping the enforcement agencies. I have a bit of a sidebar question for all of you, given your experience. How do the agencies feel when they lose a big case? So for example, the agencies decided to challenge AT&T's acquisition of Time Warner or Warner Media, what is now Warner Media today, an acquisition which is clearly of questionable success, because it's, I think, a sort of unfinished story. But nonetheless, that was one of the most notable challenges by the agency, but it was turned back by the courts. How do you think that affects the motivation of the career staff and others within the agency to think about using antitrust policy, or frankly, going to go beyond the very precedent-based limits that may be most comfortable to someone in the enforcement agency?
We called the IBM case, this is a slightly older one, the IBM case, our Vietnam. That's how losing feels in the agencies. I think AT&T Time Warner is a really important example of this troubling trend we've been talking about. That was the first really significant vertical, meaning AT&T and Time Warner are not particularly directly horizontal competitors for one another, though there was a good story of why it could have anti-competitive effects going forward. I'm sure, though I haven't talked to anybody on the inside, that the agencies are going to be much more cautious about bringing, it's been, I don't know what it's been, 50 years since there was an important vertical merger case. It could be another 50 years. And that's given up an important thing. I think more generally, good about doing it as law enforcement. The thing that's good about doing it as law enforcement is that you think, I got to send some kid out into federal court to argue this case and win it. And boy, that's a bracing, analytical, sharpness-inducing environment. But when the courts are extremely unsympathetic, that moves from making the agencies be really sharp and careful in case selection to make them back off way too much stuff.
I would say, Gene, you could use a sports analogy and say, you've got a football game, and if your team loses, everybody's really bummed about it, especially if it's a really big game like the Super Bowl. But I think the thing to recognize that makes this different and more fraught is that you can lose, and AT&T Time Warner actually might have been more in this vein. You can lose with a decision that you think the judge didn't understand the facts, but they're not advancing terrible precedent in terms of the law. Or you can lose a decision in which the judge, or if it's appealed, the appeals court, or all the way to the Supreme Court, comes up with an opinion that creates really terrible legal precedent, which will then be followed by other courts. So the American Express case would be my shining example of that, of an absolutely terrible Supreme Court opinion, an appellate court opinion, but the district court, I think, got it exactly right. And the other courts refused to really look at the facts and came to some really terrible conclusions that's now having an impact on others. So I think when you think about the agencies and how a loss affects them, they're bummed to lose, especially because the folks in the agency believe that they had really good evidence to suggest that this was anti-competitive behavior that needed to be stopped. But I think this additional impact of bad precedent is something that's important for us to recognize. And my guess is the agencies have over time demonstrated greater concern with these vertical mergers, like the AT&T Time Warner one. The ones before that tended to be settled with some behavioral restrictions that we've now realized generally don't work. When I was at DOJ, there were a couple of vertical mergers that got far enough along that when we expressed concern both about the anti-competitive effects of those mergers and the inadequacy of behavioral remedies, and said we're going to investigate, and I think an implication might have been therefore potentially challenged, they were abandoned. So we don't have those as precedent. That doesn't help us in terms of precedent, but I think it does suggest kind of a long-term interest, at least by the agencies, in trying to correct this notion that that vertical mergers are not problematic mergers. And that space, I think also it's important to highlight, is kind of what's wrong with much of antitrust enforcement today, is that we've got some theories that are being proposed as facts about the benefits of mergers or the benefit of certain types of conduct, when there's really not a lot of economic empirical evidence to suggest that that's the case.
Yeah, just a quick, I agree with what Nancy said. Just a quick addition. When a case is lost because the judge didn't agree with you on the facts, usually the lawyers understand, boy, we had a problem there. Turned out our witness went south, or our expert analysis didn't withstand scrutiny, or whatever it might be. And that's an unhappy result, but it doesn't demoralize you about the process. But the problems right now are twofold. One, there clearly is a lot of ideology in the federal courts. The American Express case was an extreme example. But beyond that, antitrust is extremely complicated now. It's really, in many ways, excessively, one might think, technocratic. So some of these issues, I think the Qualcomm case is an example of this. I think the court just didn't understand it, just couldn't grasp the theory. I'm not sure that they were driven by a result-oriented desire to prove this rule for the defendant. But what they did, I'm conjecturing now, is when they didn't really understand it, whether they were aware of this or not, they kind of defaulted to preconceptions. And the preconceptions in the bar these days are some of these notions that Nancy was referring to that were kind of nice, important insights in the 1970s about the ways in which antitrust can do harm and why we should be cautious, that have just been taken now as religious dogma and make it very difficult to persuade judges to reach different results.
Ideology makes you stupid. And it is more important in our current political and intellectual environment than it was before. You know, a true statement, vertical mergers can sometimes be efficient. Gets promoted to vertical mergers are always efficient. Or a true statement like, an exclusive distribution contract. A moment's thought will make you think an exclusive distribution contract can either exclude competitors or get the incentives of the distributor right to push your product, right? So if you think ideologically in it, always without regard to the facts and modes of competition of the particular industry is either efficient or inefficient, whoa, then you get in big trouble.
So let me pick up on all these comments, because I think what you're suggesting is that traditional antitrust, anti-competitive enforcement objectives seem to have been clear, and there was a general consensus about the benefit to society that was achieved by virtue of strong enforcement. Over time, that the quality of that enforcement has not been consistent, both because the courts have been more narrowly interpreting the law, or choosing to get confused because it's too complicated, and therefore they defer to not doing something that tries to establish new precedent. So they've been wary of wandering into areas where they either don't have a foundation or they don't feel that they understand what they're dealing with. And yet at the same time, we started this conversation by observing that all of us in the past 10 years have now become clients of, users of, participants of, et cetera, big, enormous platforms that influence everybody. Kind of unprecedented experiences interacting with these big institutions, these big organizations. And at the time that that's happened, antitrust application is, I think you're all suggesting, become a little bit softer or a little less effective. So the tools are being eroded by virtue of a number of different factors, at the same time that the need for something is greater than it's ever been. And the pressure is, do we redefine antitrust, or do we allow the populist fervor that I think Doug mentioned was behind the Sicilian bill and the sort of House efforts to go after big tech to inform a different sentiment? And I'd be very interested in your points of view on that. I'm going to come back to some questions from the listeners. But one of the big questions is, how is it different in the US versus Europe, where there's a different experience of enforcement of regulatory oversight and a different foundation, which is both multinational and somewhat sterner?
Well, let me, in the silence from the others, let me begin a stab at that. I think the four of us, Gene, you and the three of us who are on the panel, could probably sit down maybe it'd take us a couple of days and come up with a pretty good piece of legislation that we think would make the kinds of incremental adjustments to the competition laws that the three of us are talking about. And I think the Klobuchar bill is an effort to do that. Whether it succeeded, obviously people can talk about. But the problem is, even if you draft great legislation, it's not entirely clear to me that Congress can enact great legislation, because it almost always is going to be subject to the risk and maybe the likelihood of unprincipled political compromise and so on. So you have that as a threshold issue. There's another problem, though, it's really important here. And this goes a little bit partway toward answering the question about Europe. In the United States, competition law is not like European law, which is enforced by the European Commission or the member states. It applies to almost all aspects of U.S. commerce that affect interstate commerce. And more important, it is decentralized in its enforcement. Any private party injured can bring a lawsuit before hundreds of generalist district court judges around the country. So the optimal competition law or antitrust law in that institutional environment has to make compromises so that the law will be predictable, will be comprehensible, will be enforceable by generalist judges. And many of those compromises would probably cause the law to deviate from the kind of law that we would draft if we were answering a different question, which is, well, let's draft a competition law for the big tech platforms. One example, just without belaboring this, is refusals to deal, going to somebody and saying, I want to buy X from you, or I want a license to your IP. The law appropriately is very cautious there, because we don't want would-be competitors to free ride on the first mover, to lose incentives for their own innovation and the like. But interoperability, which is a form of dealing, might be essential to enabling competition with these platforms that benefit from network effects. So we may want for the platforms a customized competition law. Whether that's a good idea or a bad idea ultimately is a hard question. But the point is, US law is constrained a little bit by this institutional context, and to some extent that explains, I think, the differences with Europe.
I think that's a really interesting point, Doug. And Gene, if you look not just at the EU, but at the UK, which is doing some really innovative work in this space, you know, one of the things that they've decided in terms of one of the recommendations that's come out of their digital markets task force is a kind of twin track of regulation and competition law, competition enforcement, and in the regulation space, they're talking about or recommending quite tailored kind of codes of conduct to individual companies or individual spaces in the market, out of a recognition that kind of one size fits all might not be appropriate or desirable. As someone who started their career as a regulatory economist, I recognize that, you know, just as Doug said, will we get, you know, anything like, take the Klobuchar bill, would we get anything that looked like that at the end of a process if we actually got to the end to enact something? You know, the political process, the give and take, the lobbying and whatnot can really generate quite dramatic departures. Regulation is similarly subject to all of those problems. So it makes me a little bit nervous. It makes me somewhat less nervous that the way this is being approached is not to be incredibly prescriptive about what companies do or don't do, or what prices they charge, or what markets they enter, but more to try and create some rules that maybe level playing fields, or allow for this, as Doug mentioned, allow for some access to the dominant platform that might be needed for potential rivals or people coming in from adjacent areas. It's a challenging problem, but I suspect if we're going to make real progress, and I don't hold out a lot of hope for this, but I think kind of those twin tracks of some reform of the broad antitrust law that needs to happen regardless, even if we didn't have a tech problem, needs to happen. And then maybe something that is more focused on the particularities of markets like these, where it really is competition for the market, not competition in the market so much.
So Gene, let me pick up the other half of your question, since I agree with these guys too much on this part. the the populist instinct here, I share to an enormous degree. We have a catastrophe of declines in social mobility in American society and in income and wealth inequality. We can't look working families in the eye and say, keep your kids in school and give them good values and they'll be richer than you. Because that's like pretty much an expectation false for the bottom half of the income distribution in the United States. That's a catastrophe. But I just don't see how, like breaking up Facebook and Google is in your top 20 things you want to do about that, right? There's all kinds of things you might want to do about that, from thinking about schools to thinking about tax policy, to thinking about other exclusionary things in the labor market, not in the product markets. A mismatch of tool and task to put the great big questions of inequality on antitrust policy. It needs what it needs to do, what it can do well, and that may involve more sectorally targeted rulemaking, exactly as Doug and Nancy said.
Could I, it does occur to me we've strayed very far from maybe the original discussion that we had. I do want to highlight just, one or two things from the recent monopolization cases that have been filed against Google and Facebook to highlight problems that should be amenable. Again, I'm just taking the complaints, assuming the governments can prove up the cases that they've claimed in these complaints. But these that should be amenable. So the poster child for me is the discussion in the DOJ Google complaint about the Apple Google exclusive contract, and not for default search, and not just that exists, but that is viewed by Google as being so valuable that it's willing to pay billions and billions of dollars, 15% of Apple's revenues, something on that order of Google's search revenues, to get that exclusive, which, as an economist, I say, okay, that clearly seems to have a lot of value. Why is that? And my conclusion was, it can't just be that Google search is great, because if Google search is great, Google can say, and if it's easy to change defaults, then Google says to Apple, we're not paying you anything because your users are all gonna go to Google anyway, so we're not gonna pay for that. I personally think one of the more plausible explanations for that is it's a payment to keep Apple from coming into Google's space. That kind of exclusive behavior or collusive behavior, although it's not alleged in that way in the complaint, should be something that both infuriates us and should be something that's amenable to prosecution under the antitrust laws. And the fact that these companies could sign that without apparently worrying too much about that is, again, the type of situation that I think is evidence of under-deterrence, that we're just so far away from being able to deter exclusionary behavior or this moat building.
Raises an interesting question. My sense is that's a contract that has been around for a long time. And when it started, these companies were both less dominant and much smaller. So while it's a big number today, it's sustained, of course. And the question is, when you see something like that, how big does it have to be before you're ready to attack it? Because if it's done at some level when it's still very young and there's all sorts of potential competition that hasn't yet been, if you will, defeated by the dominant platform, it's harder to see it. So how do you can enforce it once it becomes obvious that it's big enough to be a target, which is, I think, the heart of the lawsuit against Google today. But how do you deter it, if you will? And maybe by enforcing it today, you deter it in the future.
Well, right. And I think not just for the companies that you're enforcing against, but for other companies that in the future are thinking about that. I will say, I'm not sure the argument that Google's never been dominant in search is factually correct, but you may have better data on that than I do.
Well, they're certainly dominant today, and there was a time.
And I don't mean never, but
Right.
you know, probably before that initial contract was signed.
Remember, for a long time, Microsoft Bing was doing exactly the same thing, buying positions with distributors of other technology and paying for positions. I'm not trying to defend anybody's behavior. I'm just saying one of the issues is when these things become so big, then it's apparent. And how do you get to it sort of as it's developing? How do you think about these problems?
Let me suggest a note of modest optimism on this point. The Google complaint is interesting for many reasons, one of which, maybe the most important of which, is what Nancy said. But it is not path-breaking in law. I think the legal doctrine is pretty good if the facts support those allegations. If the facts are that the consideration paid by Google cannot be explained by some legitimate reason, and I can think of defenses, I won't take the time right now to go into them. And if the default explanation becomes it's a payment to keep Apple out of competing with it, it's pretty clearly illegal under existing law. Now, if you're right, Gene, that when it was entered into, it wouldn't have been illegal. Existing law probably, although the case law is not settled here, probably would say, well, okay, but after a point, you can't continue to enforce that agreement. So I'm kind of optimistic that if the facts are good for the plaintiff will win that part of the case.
It falls well within the, even if you don't accept the contentions of the complaint as true, DOJ complaints tend to have pretty true contentions in them. They're pretty careful. Even if you don't accept the contentions of the complaint as true, that it falls well within the analytical frame that antitrust is set up to use. You know, it on its face, it looks exclusionary. There might be a pro-competitive business justification for it. Google will have every opportunity to demonstrate that in court. Courts can take a look at whether that, you know, which of those is the more plausible and get on with it. You know, there's this, you know, I think this is optimistic. I think by the way, I think it's also another source of optimism for me has been that not all the business differences among the various tech giants have been resolved by a contract and a payment. Maybe too many have, but you know, Facebook and Apple appear to be be ready to have a looming fight about privacy. You know, one of the other, Facebook and Apple are not particularly head-to-head competitors, but Facebook is an interesting partner for potential future competitors against Apple in almost all its lines of business. And Apple is an extremely interesting partner for potential future competitors against Facebook in its main lines of business in targeted advertising and social media. So we see considerable conflict, even when there's not direct horizontal competition, as we used to in the PC business. And if we could deter the anti-competitive contracts put in to support each of these firms in its current line of business, we might get some outsiders taking a shot and changing the world.
Okay, I want to turn to some of the questions that we've had from people listening in and viewing all of this, because they bear upon a part of the conversation or really all of the topics. And there's some very interesting ones. I'm going to go back because one starts with history, which was an observation that between the 60s and the 1980s, there was a lot of focus by the federal government on antitrust regulation in the field of industrial economics. But that seems to have gone away since 2000. And do you have a view of why that's the case? Was there anything that was different in that period that we can learn from today that might be something that we bring into the current milieu? I don't know who.
So, I think that's a bit of what you got sort of hints of in various of the comments that we've made, is that, there was the convenient label is the Chicago School of Antitrust, but or the Chicago Revolution in Antitrust, which took where antitrust was and frankly where industrial organization was kind of in the roughly 1970-ish, early 1970s, and argued that that the decisions that courts had been making up through that period were reflected over enforcement, reflected decisions that blocked behavior that would have been in the economic interest, would have expanded economic welfare. By the way, I'm not sure how much empirical evidence there is for that, even that thesis, but that was sort of the thesis. And then as we've described, what's happened is, and in part, I think it's been a very concerted effort by the anti-enforcement community. It's not all businesses, but many businesses supported this. And there's been an effort both at judicial education to convey the sense of, Tim's mentioned, I think, kind of theory as fact, that it could be that vertical mergers are efficient, somehow eliding into vertical mergers are efficient, or it could be that large firms have lower costs and create more surplus, into large firms create more surplus, and so we should not block mergers. So that ideology, I think, became quite extensive in the judiciary, and that's, I think that's part of what's contributed to at least the last 20, I would say last 40 years.
Meanwhile, the economists were beavering away, measuring market power in more and more industries, finding that the idea that there were few industries in which there is a market power problem was false, dramatically improving the toolkit for the measurement of market power, some of which has spilled over into antitrust enforcement, by the way. The movement from a pure market definition and market shares frame to more of a unilateral effects frame in product differentiated consumer industries. That's a big analytical step forward. So I think, I think the question a little bit reflects the spin that's been put on the role of economics and industrial organization economics in particular in antitrust, that we're sort of against enforcement. No, we're not.
Although it may well be that, and what Tim said is absolutely right. I think in many ways the tools have improved and expanded, and they certainly don't suggest a blanket argument against enforcement, and if anything, suggests that there are real problems and costs that antitrust should affect. But I think, to go back to something that Doug said, I think industrial organization economists do share some of the blame for making the practice of antitrust extremely technocratic. I think we now have judges that expect, if you can't prove to the fourth decimal place that a merger is anti-competitive or prove consumer harm, that then it doesn't exist. And I think that creates real problems. It might be straightforward to do that in some horizontal mergers, but it's very difficult to do that if the harm is to innovation, for example. And so I do think our field, my field, Tim's field, does share some blame for having made now these cases, or created the expectation that these cases will be so econometrically complicated and technically difficult that judges may be tempted to just throw their hands up and say, well, the CEO tells me there's not going to be a problem from this merger, like they did in the Sprint T-Mobile merger, and they look like honest guys, so I'm just going to believe them.
Let me just kind of, if I can, marry the comments that Tim and Nancy just made. As I see it, maybe from a lawyer's perspective, the big fundamental difference in contemporary antitrust economics and what it was a few decades ago is this idea of differentiated products. Instead of simple price theory models where you could look at, you could assume homogeneous competitors and talk about market shares and markets and the like. Now you have differentiated products along a continuum, which potentially means you could imagine all sorts of competition, all sorts of people are out there saying, gee, Facebook and Google are competing against each other, what's the problem? It also means, however, as economists have demonstrated, that two companies that are clearly a subset of what might call the market can together, if they were to merge or collaborate in some way, exercise a lot of market power. It also means that the most likely entrance and the most likely way to promote competition might not be by a Me Too competitor, but might be a differentiated competitor. And all of that complicates the economic analysis and leads to the problems that Nancy was talking about.
Okay. Questions from the listeners or the viewers that I think relate to this topic broadly, and they start in slightly different places. One makes the observation that, and really it starts with a question, is it true that unlike Europe, but the US under Stanford professor William Baxter changed the role of antitrust law? I think, Nancy, you were getting to this from just protecting against anti-competitive behavior to include a strong emphasis on acts that, while anti-competitive, may actually benefit the public. If that's true, if in fact that mindset, that ideology, as Tim may have suggested, is true, isn't it also true then that Europe is going to be faster to prosecute and go after anti-competitive behavior and more effective than the US? That's on the one hand. On the other hand, there's another question that says, how do we balance the need for competition within the United States, where we have the domain, with the need to maintain our competitive position, that is the US competitive position, relative to large foreign firms that operate in countries with looser antitrust laws? And I presume people think about China, where I'm not sure there is the concept of antitrust. But it's a big question that gets back to the original question. These platforms sort of challenge traditional definitions somewhat. So I'm interested in any perspectives you have on that.
Let me take the first part of that, if I can, very briefly. Bill Baxter was President Reagan's first head of the Antitrust Division, and clearly came in and with a sudden breath that there's a new sheriff in town and changed the way the antitrust policy was made. But I don't think you can put this historical change on him, because a similar change was made by the Reagan commissioners at the Federal Trade Commission, and it was part of a much broader intellectual change in the economic and antitrust community. So Baxter was the embodiment, he was the person, but if you want to give credit to any individual, you got to start with Reagan, I think. As to Europe, Europe is different from the US, not just because it didn't have President Reagan, it did after all have Thatcher, but in part because they have a very different normative approach to these issues. They are not as focused on competition as US competition law is. They're much more willing to intervene just to guard against monopoly, because I think monopoly is excessive, even if you otherwise would prefer economic welfare. And they're much more comfortable with regulation, which makes them much less concerned or worried about the government enforcer or the government regulator getting it wrong. Those differences, I think, go way beyond the influence of the Chicago School.
I will say in some domains, Europe's not that different from us. So I think in the merger space, the way they decide merger cases generally is not dramatically different than the way we decide merger cases. I had the opportunity to work with European counterparts on a number of cross-border mergers that affected competition both in the US and Europe. And it was quite similar. I think Doug's absolutely right in terms of conduct. They have a different statute. They have the ability to go after what they call abuse of a dominant position, which is not monopolization. So if you're the big player in a market, you're more restrained in what you can do in Europe than you would be in the United States.
They also have the political advantage that the largest obvious defendants are outside their countries. So that's made it easier in a context where the antitrust enforcers report to a political body rather than a purely judicial one.
In the tech space.
In the tech space, exactly.
Yeah.
In the tech space. But,
right. It's one of the reasons why the idea of a tax on the tech companies is most strongly supported in Europe. I think that makes some sense.
Although there are states, right? There's U.S. states that are looking at that now, is my understanding. So
I want to get to another question, which is interesting. And somebody asked the question, I wonder what the panel thinks about Apple's recent change in iOS 14, where Apple has imposed an opt-in gateway for external advertising platforms, while Apple itself has access to all of the relevant consumer data. Is this a good example of self-preferential conduct that is anti-competitive?
don't everybody jump at once. It's an interesting change. As someone who uses Apple, at least 2 Apple products, I will say, I wish all of my technology gave me that opportunity, even if they were holding on to it. Even with that, I don't feel I'm getting as much privacy as I wish I were getting, but there are just enormous impediments to consumers being able to understand what data are being collected about them and to do anything about it. And we as a country have decided to just, throw our hands up and say, we're not going to worry about it. And I view that as one of our greatest shortcuts, apart from California. So you guys out there are doing something in that space. But even then, I think even that, and even GDPR, I don't think really grapple with the complexity and severity of the privacy and data collection issues.
When the California and European privacy public policies are, partly because they are hard, very complicated, and they've had the undesirable side effect of making compliance easier for great big companies like Facebook than for smaller companies like single product firms that might want to advertise a little bit to their own customers. And so there's been this undesirable tilt in favor of large companies through restrictions associated with just the fixed cost of compliance. So that makes me more sympathetic to a private actor coming in and trying to do a little consumer protection because, they don't have to write a law.
The antitrust issue there is a tough one. Here's why. Now, on the face of it, it would appear the policy would appear to disadvantage competing vendors, advertising suppliers, in fact. And if Apple is thought to have market power in that space or to gain some kind of competitive advantage, then that would be an illegal restraint unless it serves some legitimate purpose. Well, the legitimate purpose here, I take it, is to benefit consumers, make the product more attractive to consumers by the kinds of privacy protections that Nancy and Tim have talked about. It may look discriminatory on the face of it, but I suspect Apple's answer to that is, well, everybody opts in when they sign up with us. So we have the same system, and they just assign the page, the document. We've all clicked on the document, now this is read. So it's not really discriminatory. If Apple can choose, can prove that that's a legitimate benefit to consumers, it couldn't be achieved in a way that had less harm on competitors, then you have a case with both benefit and harm, and that's where antitrust law has the greatest difficulty. Courts try to avoid that. In the Microsoft case, the judge basically found that Microsoft's justifications in almost every case were just false. There was no justification at all. When you have both, antitrust law struggles, and that's an area where the kind of recalibration that we've been suggesting might be very fruitful.
So let me ask you the last 5 minutes that we have to speculate a bit from where we are, just given the current state of antitrust enforcement with its challenges and with its aspirations, I suppose, if you could assign it some personality, and the broad range of applications for antitrust law in competitive behavior, in particular because of this phenomenon of the tech platforms and these enormous companies. And then you see both the populist strand of reform or attempted reform and a more conventional modulation of how effective antitrust enforcement might be improved or modernized. How do you see all this evolving? I'd love to get your impressions. Where will we be, 4 years down the road, presuming that we've had a period of time where there's a sort of sensible, stable debate about this, even if there's no policy outcome?
Quite an assumption.
Who wants to go first?
I'll go first. I suspect most of the tech-oriented policy initiatives, whether in this we talked about at the beginning of this meeting, are going to gain a lot of theoretical traction with populists, but not gain a lot of real markup of bill traction, because you kind of have to agree on what you're trying to accomplish to mark up a bill. So I would expect actually little or maybe some nice symbolic bills from the legislative side. I think that the two different colors of states in the United States are going to continue to bring antitrust actions against the tech companies, in two clusters, as they've shown a habit to do lately, and that'll give the courts something to chew on, which is different than what the DOJ and the FTC want to do. We got a lot of new competitors from Web 2.0. We got a lot of new competitors from mobile. We didn't yet get a lot of new competitors from AI. Although I think, if you stand by the SIEPR summit tomorrow, you'll learn a lot about the prospects of that from Eric Brynjolfsson and Susan Athey. I would forecast that there's a better bet of improvements in competition in this area more quickly from either that round of major technical progress or the next one, and that it's a long, slow haul to improve the public policy.
I think I generally agree. I don't think the Republicans are going to be supporting a generalized uptick in aggressive antitrust enforcement. They want to bust up, they really want to bust up Twitter. And I'm not sure there's going to be a consensus in Congress to do that either.
And I'm not going to predict that we get it, but I do think we're closer than we have been in a very long time to seeing some bipartisan recognition that the pendulum has swung too far. And maybe it starts with the merger space, and maybe sort of around the edges, some of this, some of the problems we've raised with conduct. I don't think that, it's certainly not a slam dunk. I think the odds are probably just as, if you talk about any major legislation, I think the odds are against it in this current political environment. But I do think it's a better shot now for some potential kind of cleanup of antitrust, not a populist bill, but some potential kind of pushing back than we've had. Yeah, maybe that's just hopeful, but that's where I am hoping.
I agree with that.
Yep.
Great. Well, this has been a really interesting discussion with three incredible experts with tremendous experience and really great judgment about the quality of our laws, the quality of the enforcement of our laws, and the complexity of trying to apply the public's interest to that enforcement. So I think we all come away from this with a strong sense of respect for the challenges involved in campaigning in this environment, or frankly, any environment on issues this challenging and difficult. So very much appreciate it. I turn it back to Mark.
Thanks so much, Gene, Tim, Doug, and Nancy. The four of you provided a ton of great insight and information in this session, and I'm so very grateful for all of you sharing your time with us today. Thanks also to everyone in the audience for joining and for sending in your questions, and I hope that you'll all join us again tomorrow for our session with Microsoft CEO Satya Nadella and the chair of Stanford's Board of Trustees, Jeff Rakes, along with the session that Tim mentioned. For those of you registered for our exclusive SIEPR Associate session on global development, we'll be gathering for that shortly, around 1:30 start time. See you soon, and thank you so much again to every one of you for being with us for the SIEPR Economic Summit, and again to our panelists and to our moderator, Gene. Thank you so much.
Bye-bye.